Welcome to the iGM Conversations, where we bring clarity on money, markets, and what it means for you. So from 1st April 2026, the Singapore government will permanently waive the $70 application fee for lasting power of attorney, LPA Form 1. This is aimed at encouraging more people to plan ahead while they are healthy. Right now, only 1 in 7 Singaporean citizens has made an LPA, and among those aged 65 and above, only 1 in 4 have done so. So clearly, there's actually room for more families to take advantage of this LPA. So to help us better understand not just the process, but why LPA truly matters, we've invited Derek from iFAST Global Markets, who specializes in LPA planning. So before we even go down to the emotional part of it, right? For listeners who isn't really clear what exactly is an LPA, maybe you could just give us a good overview on what exactly does LPA mean.
LPA is the lasting power of attorney, which is a powerful legal document that empowers a person, a donee, we call it a donee, with the power to decide for you on your behalf in the event that when you lose mental capacity. So the two broad areas that the donee is able to assist will be your personal welfare and then as well as your property and affairs.
So share with us a little bit more. Personal welfare, what does that really entail?
Personal welfare will entail in the aspect that, let's say for example, the donor, which is the one who wrote the LPA, the donor may have certain preference in the sense that, let's say she loses her mental capacity. There's always option whether you want to put her in a nursing home or being stay at home with maybe a domestic helper. So these are decisions that the donee with the LPA will be able to decide for the donor. So as treatments, there are a wide variety. For example, sometimes it could be reached a stage where certain medication no longer work. The doctor may prescribe certain experimental drugs which you want to grant your donee the power to decide whether to allow the doctor to use experimental drugs for the treatment as well. So these are, and as well as life-sustaining treatments. So these are how they fall within the personal welfare.
But I think there's always a common question, right? So can this person make the decision to decide if I carry on living or not in the case of like coma? So does this still covers under LPA as well?
It still covers under LPA, but there was some overlap with another document called Advanced Medical Directive. So, but that one would be a topic for another day.
Okay. So what about property and affairs decision? So what exactly can the donee make when it comes to property?
So property, basically, donee actually get access to the financials of the donor. So in the event that, for example, certain their mortgages that needs to be paid, or there are certain liabilities that needs to be covered, the donee can help the donor to use her or his assets to be paying off all these liabilities.
I see. So that definitely sounds like it's a huge responsibility on the donee side, right?
Yes.
To be making all these huge decisions for the person. So what if some people are not comfortable? Let's say that I don't feel safe to leave it to entirely one person to make the decision. Is there an option to have a joint decision?
Yes, so under the basic LPA that most of us will have access to, you can actually appoint up to 2 donee concurrently, and then you can decide whether you want both donee to operate independently or they need to jointly make a decision for you. So to some individuals, probably a joint decision will make more sense to help safeguard the interest as well.
I see. Okay. So we understand that from 1st April onwards, the $70 application fee is permanently waived for Singaporeans. So does that mean getting LPA done now is completely free?
No, it's not exactly free. So there's this quite a common misconception. So there are press that I spoke to. So probably to take a step back, you need to understand how the whole process of LPA is done. So I'll classify into 3 major steps. So first step is identifying who your donee are and what power do you want to grant to the donee. So that's the first step. Second step is your donee have to accept the appointment. You will not be, the LPA cannot be completed.
Okay.
So step 2, the donee has to accept it. There comes step 3. Step 3, you will need we call it a certificate issuer to verify and to confirm that whatever the donee has assigned and appointed is truly her wishes or he or his wishes. And then and also the decision is made out of a conscious mind. Then the certificate issuer will certify the LPA, and then the whole LPA will be submitted to MSF, and then you'll be considered completed.
Okay.
Such as
Who are the people that can certificate?
So for For certificate issuers, usually we have to engage a third-party professional. These professionals can be either a doctor, a lawyer, or a psychiatrist. So whichever you choose, I think it depends on personal preference as well. So for example, probably some certain businesses, they do engage a lawyer regularly. If they feel comfortable, they can engage the same lawyer to help them to certify the LPA. Or to some, they may have family doctors they go to regularly, whichever works for them. But at the end of the day, I think the doctors also, the certificate issuers as well, wanted to understand and know the patients well about what they're thinking, why they're going through this whole LPA process.
So, I understand the part about having professionals certify that you're in the right state of mind when making this decision, but when it comes to, say, visiting doctors, lawyers and all, the common perception is it's very costly. So even the government waived a $70 registration fee, right? How much, or is there like a ballpark figure on how much the sort of doctors and lawyers will actually charge so that our viewers can actually have an estimate in terms of what's the costing like for getting an LPA done?
It's quite a wide range. I think the lowest cost I've seen is about $30 per pack. Highest range I've seen can go up to a few $100 or even $1,000.
So is there like a real difference between going to a doctor versus a lawyer? Or is it like, I would assume lawyer actually costs more because you mentioned doctors can go from just probably like a normal GP is able to certify at $30. But so, being a Singaporean mindset, does it mean I pay more means I get more areas covered or a little bit more assurance or more checks are done in the event if I were to go to a more expensive, let's say lawyer or even psychiatrist in this case?
If you're talking about the basic LPA, I think there isn't a significant difference whether is it a doctor or a lawyer. Primarily is someone that you feel comfortable with, that you want to be talking about certifying LPAs.
Okay. What are the common questions that they may ask during the certification process to determine that?
Okay, because I did one myself, I also brought my mom to do. So they were really, firstly the doctor, both for me and my mom, what we wear, we see the doctor. The doctor, first they will do a check to make sure that you are a conscious mind. So they'll ask things like, what do you have for breakfast this morning? Or what do you do to utilize the recall function of your brain to make sure that you're of conscious mind. So once the test is done, then they will check through with you who's the donee, is it and what power are you running to the donee, to run through the whole application itself. And once the donor certifies that yes, this is my decision, that's when the certificate issuer will sign off issue up the LPA.
I see. So the entire process is actually pretty, it's not too lengthy, right? It's probably just like maybe a 10-15 minutes.
Say, yeah, 10-15 minutes.
Yeah, okay. So you mentioned that is for the basic LPA. So LPA, we understand there's two different types. There's Form 1 and Form 2.
Yeah.
Can you just maybe briefly share with us what's the key difference between these two forms?
Okay, so Form 1 Form 1 for LPA give very basic hours to the donee itself in terms of their personal welfare and property affairs. Form 2 is slightly different. But Form 2, I would say it's more like related is like a complex review where there are certain terms and conditions that you want to put in place to safeguard the risk. So I would think, from my experience, Form 2 are mostly used by individuals where they have more complex family structures or even complex assets. Like they could have multiple properties or they have various different family dynamics that they want to have different arrangement for.
I see. So for people, let's say for example, like a normal working class, actually the Form 1 is actually more than sufficient to safeguard whatever it is required. So in the event if you manage to accumulate more assets along the way, or probably family that nucleus gets a little bit more complicated, then there's a chance to, is it an upgrade or is it like a completely new application when that happens?
It's not a technical upgrade, but every LPA is viewed as a single application. So when you do a new one, you just automatically replace the old one. So be it the new one, the new LPA can be either Form 1 or Form 2, it doesn't matter. You will just replace the old one.
Okay.
So I would say that it really depends on your need, the suitability of whether Form 1 or Form 2 suits
what you're looking for. I see. So basically, the submission of LPA, everything is done digitally online. Okay, so the selection of a donee, does it have to be someone that is related, like family, or it can actually be a friend or like a colleague or even a financial advisor? Is there any restrictions on who an individual can actually appoint as a donee?
There's no restriction on who you can appoint a donee. But I think fundamentally, the thing about the donee as someone that in a position of trust is someone that you really will trust your life with. So naturally, most people will think about their family members, but it's not true for all cases. I have a case where husband and wife, the wife explicitly told the husband, I do not want to be your donee for LPA. Not because she doesn't love her husband, but she feels that the responsibility that she needs to decide. She said she couldn't imagine that if her husband is in certain medical crisis and she needs to make that decision, she feels that she'll emotionally break down. So she told her husband, I'm not the person you should assign as a donee.
So who did he appoint ultimately? Because I mean, the spouse is naturally the first person that probably knows your assets, your wishes, the closest, right?
So and then the husband assigned her sister to be the donee.
I see.
So actually thinking a step back, when you talk about thinking about a donee, right? It's not just because the last thing I want our listener is to treat the whole LP as an administrative process. Because donee also is a responsibility that we need to talk to them, discuss with them whether are they willing to shoulder this responsibility. Because sometimes I've seen cases, I've seen people during crisis, people's true nature comes out. Unfortunately, not everyone is able to handle crisis or able to handle that kind of stress. So I always feel it's good to have this conversation with the donee. It's a two-way thing between the donor and donee. That, something happened to me, are you able to step up? Are you able to really take care of what I want? Most people, we don't. Thankfully, I mean, in Singapore, we live through very peaceful times, so there isn't much crisis that we need to consider. But there are such situations, so I think it's a topic that is for the donor and donee to really.
I think also probably to decide whether this person is able to handle finances and make clear decisions in the event of crisis and the event of conflicts, because I think ultimately if the responsibility is on the donee to be managing huge amount of assets, etc., there's probably going to be a lot of disputes from people around, especially if it's someone wealthy, right, with a lot of assets and everything, then naturally you will have a lot of noises and a lot of people disputing on questioning whether is this the decision. So I think there's a lot of examples in cases whereby we've seen in the newspapers where people just appoint non-family members as donee, and then in the end, the funds were being used for their own personal usage, right? Do you want to share more about that?
Yes, actually there was quite a high-profile case years ago. I'm not sure if the listener remembers the incident. There was a former China tour guide, very close with a Chinese widow, Madam Cheng.
He moved into her property as well, right?
Yes.
And then moved the family over, if I recall.
Yes, so the family of the China tour guide actually moved in to stay with the Chinese widow as well. And then for some reason, I think the widow actually trusts him enough to actually assign him as the donee under her LPA. And after that, there were a lot of, what we know officially, that there were a lot of assets that's misappropriated, then up to about 1.1 million. Even her cash savings also depleted from a large amount, I think it was in 7 figures to 5 figures. So, but all this actually, no one knew about it until I think the niece of the Madam Cheng realized something was not right, started to flag out. And then there was investigation into place. That's when it was identified that there was a abuse of trust, a breach of trust under the Mental Capacity Act, where when the donee is appointed as donee, is expected to behave in a way that
in favor
to protect the interests of the donor. So when this is breached, actually is offense. That's why the tour guide was sentenced to jail for I think about 9 years or so.
I see. So basically, LPA actually allows people to make cash gifts. Because if I recall the entire process of LPA application, there'll be like a specific question asking, will you allow your donee to make cash gifts on your behalf? So how should someone consider this point? Like cash gifts, for example, like should they set the limit or should they strictly say no? Because by opening up, then of course, like the example that you just mentioned is probably just giving the donee free play to the entire assets that you have.
Yeah, I think rather than trying to use the LPA to restrict the power of the donee, I think it goes down to choosing your donee itself. So I think when the process of choosing your donee is someone that you really trust, like I mentioned, when you really trust the person of your life, naturally I think all this restriction will not be necessary. I think it's only important for those that when they don't have a suitable donee and then they're worried about the misuse of the assets. That's when all this can be in place. I would think that worst come to worst, if there's really no suitable donee, there's actually something called a professional deputy that they can assign to take care of your interests, because they are legally and professionally help you to run your LP in the event that you need help on that.
Are there charges on that?
Yes, definitely there are charges on that.
So it's easy to say, okay, I trust so and so. I mean, probably at this current stage, there's completely trust with whichever donee that you've appointed. But things changes, situation changes. What are the situations that may revoke a donee rights?
And there are two situations. I think firstly, if the donee becomes a bankrupt, because it will be shown that the donee doesn't have the ability to handle finances. So actually it will be voided as the role as a donee. Secondly is in the event of a married couple where they go through a divorce, either party, the role as a donee will also be naturally voided as well.
I see. So that's quite strange, right? Because I understand when it comes to CPF nomination as well as will, in the event of a divorce happening, it doesn't automatically revoke whatever that's written. It's unless you personally update the CPF nomination or the will. So why is it being treated differently when it comes to LPA? It's an immediate revoke of it once a divorce happens, as compared to CPF nomination and will writing is completely different.
See, because we talk about LPA grants broad range of power to the donee itself, and it rests on the fundamental that there's a trust. Trust the person, therefore give the person the power to on my behalf while I'm still alive. What's for between a marriage? I think a marriage happens when there's a trust between the couple itself. So when a divorce happens, in the eyes of the law, I think there's a breach of trust. That's why the marriage failed. Why the same idea will apply to LPA as well, where because there's a breach of trust, the ex-spouses should not be qualified to be a donee.
To make the decision.
Yes.
Okay. I think you've seen a lot of your clients, right? Especially the younger ones, they tend to procrastinate to say that, okay, LPA is a older folks thing. It's not something that I need to think about it until I'm probably like in my 40s or 50s. But we've also seen an increasing trend in the younger generation talking about wills, talking about planning assets and everything. So what advice will you give for people that are still sitting on this, thinking about it, or even probably haven't started thinking about getting their LPA?
Okay, I think I will just use myself as an example. I have two kids. So to me and my wife, we have both done our LPA. I think the thought came about is if anything happened to either of us, for example, let's say I lose my mental capacity, there are still bills that needs to be paid on a monthly basis. The kids' school fees, our mortgages, or any loans, or car loan and things like that. Then when my wife doesn't have access because she doesn't know the password that attached to all my bank accounts, so without LPA, as soon as no LPA, then she'll be in a lot of difficulty. I need to pay this bill, I need to pay that bill, but
where do I get the money?
Where do I get the money from? Then it becomes like, what's the alternative where she can go through to apply for a proper deputyship through the court. But it's a lengthy process. It's an administrative nightmare especially for a working mom taking care of kids, and still need to handle all these legal processes. I don't think it's a process that I want to put my wife through. So we both agree that we have LPA, we assign each other as our donee. So in the event of such unforeseen circumstances were to happen, at least, okay, I work hard to recover from my mental capacity. But I want to burden you with...
Financially, it's less of a concern because you know that there's access to the bank account and etc. So I think LPA is especially crucial for people that doesn't have everything in a joint account. Because when everything is managed in your own personal individual account, so even for example like paying off like monthly income tax, or even like kids' school fees, or even there's a lot of shared responsibility but that comes out from your own individual account, LPA will allow your partner or your spouse to be able to tap into all this and continue maintaining the lifestyle while he or she is still recovering.
Yep.
Yeah, so it's common to think, oh, LPA is only for like the old or the elderly, thinking about what I want to leave my assets to. But actually LPA is something that's very real. Even for like young parents with kids and everything, especially where even if one party collapses, life goes on because you have kids to bring up, you still have school fees and everything. So I think LPA actually helps to plan all this in advance as well, and also to open up the conversation, right? So what are some of the practical tips you have to ensure that this process actually goes smoothly and aligns with like family, or like some tips in terms of approaching this conversation with your spouse, or even the more sensitive one, which is like the elderly parents?
I think for today's, actually using me and my wife as an example, I think in today's the younger working force, when we bring out this topic, I think they're more open, they're more willing to discuss, work out the nitty-gritties. I think the bigger challenge is more talking to our parents on how to get them to start on this LPA. I think we need to have is, I would say, patience. Because being our parents, they have this mindset that this topic, they don't want to talk about it, not because they don't care, but it's more like they don't want to burden us with this kind of responsibilities at the moment, given that how life can be quite hectic at our current phase of our life. So I think we have some patience. So every now and then bring up the topic. Don't try to push it hard on the parents. So just find ways to keep talking about it. Eventually, I believe they also want to do it out of the love and care.
So for elderly folks, right, everything being digital and online, how easy is it for them? Like, what's the actual steps if someone wants to kickstart this entire application for LPA?
Most of us, the process is quite seamless, it's quite easy to understand, so it should not be too difficult. So I would think the problem with I think for elderly is they may not know how to operate all this IT stuff. So as a children, if possible, let's assist our parents as much as possible to help them set up the LPA. So LPA, the process is to share step by step to make it easier for everyone to know. The first step is having that conversation first with your donee, understanding who you want to appoint as your donee. So once all this discussion has been established, and the remaining steps are all just purely administrative. So firstly, there's this OEGO website portal. And you can just use your SingPass to login or logging in. That's when you'll start step by step. So things that you need to prepare is your donee's full name as per NRIC, the IC number, as well as their contact number. Which is 3 info is sufficient. So they will ask you to key in the details of the donee, and the next step is they will ask you what kind of power you want to grant to your donee. So basically, it's the personal welfare as well as the property and LPA. Even individually, there are certain restrictions that you can apply to it within the portal itself.
You can set a limit, right? Like not more than $1,000 or not more than $500. I think these are within the parameters that can be set within the LPA documents.
Yes, it's all on the website itself. So for personal welfare, so there's this power that you want to grant to your donee to decide for you in terms of medical treatments. So just like what I mentioned just now about experimental drugs or certain specific treatment you want to allow your donee to decide on your behalf. So that's for under personal welfare. For property and affair, there are properties that you can restrict, saying you do not want the donee to be selling your property, then you can put a restriction where the donee has to seek approval from court in order to do anything related to that property itself. So that can be an additional safeguard. Then lastly will be the cash gift that you mentioned. So whether do you want to allow the donee to use your cash to give out, or sometimes this restriction to help elaborate further is mainly for, say for myself, I give my wife unrestricted access because we have kids, we have parents that we want to take care of. So she may need my assets to be giving out to my dad, to the kids. So that's why there's no restriction. So by case-to-case basis. So to some, you can put in restriction, or you can put in even a limit how much you want to allow the donee to be using as cash gift to others.
Because gift is a very generic term, right? It can be for like anniversary gift. It could even be like a farewell gift. I think gift is a very generic term. So is there any way to safeguard this? Is there any governing body looking at the donee withdrawing the funds, or like taking the monies to give off as gifts? officially, but what if the funds get depleted or if it's used up so fast that you're not able to sustain the donor's life, etc.? Is this like a potential scenario?
It's a potential scenario. So basically, in LPA, there's a clause where the donor is supposed to ensure that there's sufficient assets to sustain the lifestyle to take care of the donor itself. Unfortunately, there's no governing body to really supervise and monitor every expenses you are using it. I think, like I said previously, it's really about choosing the right donee, ensuring that the donee is really someone you trust. So, but being said that, of course, things may change, people may change. So worst case scenario, if something really not goes well, party can actually still flag out, because the way the system operates is based on whistleblowing. If you ever notice someone with an LPA not doing something right, you can always flag out.
Not acting in the interest of the person, right? Okay.
If you feel that the donee is not acting in the interest of the donor, they always flag out, and there can be processes to come in to investigate, to double check, to make sure that whatever the donee is doing falls within the power that was granted to the donee.
Okay, so one last final question is, I think after we've been through the whole process of determining who is the right person with the right integrity to be the donee in this case, as a donor, what are the information or like the documentations that you should prepare for your donee? Because you're entrusting this person with like a huge responsibility, right? What are the areas or what are things that should be prepared in advance so that this person is able to take on this responsibility well and execute your wishes accordingly?
So I'll recommend 2 documents. One is called ACP, Advanced Care Plan. Advanced Care Plan is also another initiative by the government. So ACP and LPA actually work very closely together. LPA gives you the legal power, but ACP shares the details of everything that you would prefer in terms of what kind of treatment you like, to the stage that if I were passed on, what do I want my funeral to be like. That is encapsulated into the ACP itself. Because ACP is like, you can see ACP as a form of a guide on what kind of topics that you should talk about with your loved ones about it. So that's one document. Second document will be, I would say, is a financial summary, because LPA also allows the donee to govern part of the property affairs. So I think the last thing that we want is our donee to go around every bank to ask, hey, do I have an account here? Do I have an account here? I'll go to every insurance company to know, hey, do I have insurance with this company and this like that. So it'd be good to have a financial summary about where are my bank accounts, what kind of insurance do I have, even investments, if which platform, which broker itself. So
that the donee will potentially know where to get the funds to continue paying like the monthly liabilities or even like the annual premiums and everything to sustain.
Yes.
Okay. Thank you so much for sharing so much today, Derek. So to our viewers, LPA is definitely not just for the elderly. It's a tool for clarity, peace of mind, and definitely protecting your family. So even with the permanent fee waiver from 1st April 2026, meaningful planning decisions actually remain. So most importantly, like what Derek has emphasized so strongly, is basically choosing someone that you trust, because you are granting this person with immense power to actually manage your finances in the event if you are not able to do so. And of course, this needs to be clearly communicated to the donee as well, to make sure that he or she know what are your intentions and what are your wishes. So do share with us your thoughts or experience in the comments. We'll definitely love to hear from you. Or if you have more questions about LPA, feel free to get in touch with Derek and he'll be happy to guide you through that. Thank you for tuning in, and we'll see you in the next episode.